the president of the AAPJ. Hope you're all having a nice afternoon. Well, I hope you are. I mean, it's pouring outside where I am, so it's a nice afternoon to be on Zoom. All right, so before we start, as before, if you could mute your microphones, we'd really appreciate. So thank you for doing that. And don't forget, there's a chat box also down here. So if you have questions or comments, go ahead and type them. So we have a terrific speaker for you this afternoon, Barbara Lauriat. She is the visiting associate professor and Frank H. Marks Intellectual Property Fellow at GW. She is also the senior lecturer in law at the Dickson Poon School of Law at King's College London and a research fellow of the Oxford Intellectual Property Research Center in the University of Oxford Law faculty. Professor Lauriat earned her Bachelor of Arts and Juris Doctorate degrees from Boston University, and she has earned her doctorate in philosophy from the University of Oxford. She is a member of the bars of Massachusetts and New Hampshire. And I've also read that Professor Lauriat was called to the bar of England and Wales at the Inner Temple in the footsteps of another great scholar, Sir Edward Coke. Congratulations on that, Professor. So as you can hear, Professor Lauriat has a stellar background, and we are very proud to have her as a speaker in our speaker series. Her talk is entitled William Robert Grove, the First Modern Patent Judge. I have to be honest, I've never heard of him. I've been in the patent business a long time, and sometimes I think I know it all. This just proves I don't. Apparently I still have more to learn, so let's do this. Professor Lauriat, the virtual floor is yours.
Thank you so much for this kind welcome, and I am delighted to be able to speak to the AAPJ. I'm also delighted to be able to have a reason to go back and ask this question, William Robert Grove, was he the first modern patent judge? Oh, a slight biographical correction, because someone from the University of Oxford just wrote to me to tell me that, oops, my association with that institute expired in 2019, and Oxford being Oxford, no one noticed or remember to tell me. So technically I'm a former, but I think that it's just in the interest of absolute accuracy. So back to the subject of William Robert Grove. My interest in Grove goes back several years when I was doing research in archives at the Royal Institution, looking at the Royal Commission on Patent Law. And I had realized that Grove was a judge and he had been involved in some of these cases and that he was a member of the Royal Commission. But I hadn't realized the extent of his own scientific expertise and professionalism in that area. And as I was reading through these letters from Darwin and Faraday to Grove, I started wondering, was he, Grove, the first modern patent judge? And I put this aside, and then we had COVID, and lately I've been doing less historical research because I have not had the access to the same archives that I once had, and so I'm working more on modern legal developments. But given this opportunity, I thought I'll go back to this question of, was William Robert Grove the first modern patent judge? And who better to test this theory than the AAPJ? So you'll note, of course, that there is a question mark at the end of this title. And I don't know that I have completely concluded one way or the other. And so I'll be interested in your own contributions as to whether you think this hypothesis holds water. So first of all, of course, we have to think about, what do I mean when I say first modern patent judge? What do I consider to be a modern patent judge? And in defining that, obviously many people would have many different definitions on this, but my thought is that today when we think of someone being described as a patent judge, we would usually think that they would have some kind of technical or scientific background, usually prior to coming to law, that they would have expertise in the practice of patent law before being appointed to the bench, at least primarily or at least in part because of that expertise in a technical area and as well as with patent law. So those kinds of are the three things that I thought broadly described what I consider to be a modern patent judge. And so looking at Grove, I thought, I don't know that there's anybody before Grove in any jurisdiction that I can think of that meets these characteristics. So of course we can argue later about whether I've defined this properly. And I'd be delighted to know if you have any ideas for other possible patent judges or first patent judges. In looking at the different jurisdictions, just to see if I could find anyone earlier, I primarily focused on the UK, France, Spain, and the US. Now, there were other 19th century patent regimes, but those are really the earliest kind of formalized patent regimes that we can look at. And they, in the US, well, there's a lot to go through there, and I admit there are certainly many stones unturned as far as possibilities. But given the federal nature of patent law from the beginning, it's a little bit easier. That narrows it down a bit, although it wasn't quite as clear cut as it is today in the 19th century. And I've seen it suggested that Giles Rich, who of course is 20th century, and for whom the GW Law School IP moot court is named, that he was in fact the first kind of modern patent judge under this definition that I've come up with. In terms of France and Spain, I wasn't able to review comprehensively, partly because I lacked the language skills. So I'm definitely interested in if any examples from those jurisdictions. But I was able to do enough research to see that it's unlikely. It's unlikely based on the timing of the patent regimes. It's unlikely based on the ways that judges were trained, educated, and appointed during that period, and well, even today to some extent. So because of the career path they would have followed, it seems unlikely. So we come back to my theory that maybe we could consider William Robert Grove the first modern patent judge under the definition I described. So William Robert Grove, let me see if I can move this. He was born in Swansea in Wales in 1811. And as I sometimes joke that, given that much of my historical research on intellectual property law is set in the United Kingdom in the 19th century, I am mostly dealing with dead white men, because that's who's involved in this. I will say in this case that if we think about the time period, being born in Swansea in Wales and being not educated in one of the major public schools like Eton or Harrow, Winchester, and coming from a manufacturing family, and not having any of his other relatives go to university, certainly would make William Robert Grove an underrepresented minority in the London of his day. So he was born in Swansea. The family did have some money at this point, and obviously they invested quite a lot in his education by private tutors in Wales. And eventually he was able to be admitted to Brasenose College, Oxford. Now, at this point, you might be wondering, well, I said have some kind of technical expertise, scientific background. Of course, at this time, you couldn't study natural sciences for a degree in Oxford. He studied classics, which of course is dear to my heart because that is what I studied at university, or he read classics at Brasenose. But already he showed an interest in mathematics, where he was taught by Baden-Powell, and he apparently excelled in mathematical fields and already was beginning to have an interest in sciences. However, his career path led him to choose to go to the bar. He was called to the bar at Lincoln's Inn in 1835. So this slide, if you can see it, it lays out a little bit of his kind of legal resume. So he's called to the bar in 1835. He was married in 1837 And we don't know much about how he met his wife or about her. I've seen it suggested that they met at the Royal Institution at a scientific lecture, but I've not been able to, unfortunately, find any evidence that that was the case. But he became a barrister. He stepped away from it for several years, and in fact spent there is substantial evidence that he spent their honeymoon in 1837 writing his first important article on what would lead to his fuel cell research, which he published later. Again, his must have been a very patient wife, or one who is also very interested in his research on fuel cells. So he then stepped away from the bar. We'll talk a little bit more about that shortly. But he came back to it given the need to support his family financially, and was successful at it, becoming a Queen's Counsel QC in 1853. His first judicial appointment was at the Court of Common Pleas in 1871. He was elevated to the Queen's Bench in 1880. And he retired from the bench, but was appointed to the Privy Council in 1887, and then died 9 years later in 1896. So he certainly had a successful career in law, but it certainly was not his first love. I mentioned his work on fuel cells. So today, it is quite probable that those who have heard of Grove have heard of him because of his invention of the fuel cell. He arguably was the inventor of the fuel cell. So this is a quotation of him describing this in the initial work on this invention in 1842 in a letter to Faraday that I read at the Royal Institution, describing it as composed of alternate tubs of oxygen and hydrogen, through each of which passes platina foil, so platinum, so as to dip into separate vessels of water acidulated with acid. So he used sulfuric acid. With 60 of these alternations, I get an unpleasant shock. So he was able to, through his own experimentation, develop this fuel cell to produce electricity. Now, there's a wonderful, slight digression. There's a wonderful biography of Grove that it's a short little biography that I just stumbled upon, in fact, last week. And if I think about it after my talk, I'll put the name of the author and the title in the chat, because I was surprised to find that, unlike some, it was sort of Welsh men of science, and I wasn't expecting it to be as well researched and well written as it was. And he had come across many of the same sources that I had, and I just thought it was a nice little biography, though it focused more on the science and less, on the law than my own research. But I would recommend this little biography if you're interested in reading more about Grove. The reason I mention it now is because in his introduction, which I thought was quite fun, he talks about how maybe you could have this alternate universe, or maybe even in our future, given that there is currently quite a lot of research being done on fuel cells as means of sustainable energy, as ways as for electric vehicles, that it may be that Grove will be remembered in future years more than he is today for this invention. But at the time, unfortunately, in the form that he developed it had some utility, but it was of limited utility, and initially was used, a version of the Grove cell was used primarily in telegraphy, so for the telegraph, and you needed rows of fuel cells. Also, unfortunately, in the form of his invention, he had, it produced, particularly when you had lots of them, a slightly poisonous gas. So that was less than ideal. So they had to move to a new source of power. But he certainly, just alone, this one contribution to science is certainly not an insignificant one, particularly given that we can see from his background that his interest in science was something that he pursued initially on his own, later through his own connections and network that he developed in London, and through, and also while pursuing a legal career as well. So I am humbled by reading about Grove. So if that weren't enough in terms of scientific contributions, he also gave a series of lectures at the London Institution on the correlation of physical forces, which he published as a book in 1846. In this book, it's sort of described as kind of experimental philosophy during this period. He sets out the theory, his theory of the principle of conservation of energy. And this is published a year before Helmholtz. Now, admittedly, if you look through this, the volume, The Correlation of Physical Forces, it's more descriptive. He doesn't have the means of expressing the theory mathematically in the same way, but it is presented as, it is said to, in many ways, set forth before Helmholtz most of the basis of the principle of conservation of energy. So he is also known for that contribution. Now, the London Institution is, I'm mentioning all these sort of institutions and institutes. The London Institution no longer exists, and it was set up as partly because of the lack of opportunity for scientific and technical education sort of for gentlemen and for others at this time at the universities. And so the London Institution was set up to educate, well, inevitably men on technical and scientific and engineering subjects. And Grove was, in fact, appointed a professor there and served as a professor there for several years, during which he gave these lectures and then published this book. Unfortunately, as he was going through the process of publication, he had already left the London Institution because the salary he was paid as a professor there was not enough to support his growing family in the style of a gentleman in London at that time. So he was forced into law for the money, even though it is quite clear from his letters and from his introduction in The Correlation of Physical Forces that the scientific discovery is really his first love. So I've also barely mentioned the Royal Society. So one of the ways that Grove was able to carry out the scientific research, that he was able to share these discoveries and share his ongoing research with colleagues, was by means of these private organizations in London. Now, I'm sure many of you have heard of the Royal Society, which still exists. Grove was very involved in the Royal Society and very involved in some of the kind of infighting that was going on, various coup attempts at the Royal Society in the mid-19th century. This is a painting here that depicts the members of the Royal Society offering Michael Faraday the presidency of the society, which he refused. I believe he refused it twice, so I'm not sure which time this is meant to be. Grove is the gentleman standing in the middle. So he very much, that it's appropriate, he was in the middle of the world of scientific thought and research in London in the 19th century. He was very much a part of this. He knew everybody. In his correspondence, there are multiple letters from Darwin as well. He was someone whom anyone working in sciences in London at this time would know and respect. This is a picture of the Royal Society, of a Royal Society meeting. We can imagine this being somewhat like when Grove led this failed coup to change the way that the Royal Society was organized. This is actually in Somerset House, which coincidentally, this is Somerset House today. And my office is the fourth window from the top, kind of closest to the, let's see, it's right there. That's my office window when I am in London. So, little coincidence. Now, Royal Society, Royal Institution. The Royal Institution still also exists. This is where Grove's papers were kept. And increasingly after this infighting kind of drove Grove away from the Royal Society, or left him slightly disillusioned with the Royal Society, he spent more, he had more engagement with the Royal Institution, and presumably that is why his papers ended up at the Royal Institution. So this is Albemarle Street in London, and this is the same building that the Royal Institution, where it still exists. So we have, it's a bit confusing. So he was involved in the London Institution, the Royal Institution, and the Royal Society. So, as well as, of course, Lincoln's Inn. So he was very involved, and he certainly spent a lot of time and energy on his network, considering that this was not something he would have had coming from Swansea. And here is the London Institution. So this is no longer exists, and it's the location where it was would now be, in fact, part of University College London. So again, coming to the question of patents. So I've laid out this a little overview of Grove as the scientist, Grove as someone who clearly, even though he did not study a scientific subject at university, he was a self-taught partly, and then partly through developing contacts who could help him pursue his research and obtaining an academic position at the London Institution. He, I think, can easily be described as someone who was a scientist. He also, now the next part is that I have to establish that he had a patent practice, that he had a specialism in patent law, which he did. And one of the most interesting early cases he had dealt with William Henry Fox Talbot, who and his calotype patents. So Talbot is fairly famous in the field of photography and as an inventor of this calotype method of photography. And he knew and was friends with Grove, and knew of his legal expertise as well as his scientific expertise. And so he was one of the first to approach Grove with a patent problem. Talbot's rather, his calotype patents had been infringed, particularly by a competing Frenchman in the field of photography, and he wanted to see if he could bring a successful action of patent infringement against various parties. He wrote to Grove, and I think this is 1854. It's a little unclear, and it's from the record, but I think it must be given when the cases were brought. But he says, he writes to Grove and describes the problem he's having with the infringement, and he expresses some hesitancy. Saying, I have little doubt that on perusing this, your first impulse will be to advise me to abandon the patent in question to whatever subject it may relate. I am aware of your strong opinions upon this subject, and they have had considerable weight with me in coming to a decision upon this question. So what did Talbot mean? Your strong opinions upon the subject. What he meant was that Grove was, in fact, generally opposed to patent protection, did not think that gentlemen of science should be obtaining patents, thought that they were destructive to the development of industry and manufacturing, and was broadly in favor of abolishing the patent system. I just don't know why this is a little bit off, but patent abolition in the middle of the 19th century was a fairly powerful movement in Britain. It was not as strong in the US, but in Europe, I'm sure that many of you have heard about the Netherlands abolishing its patent system for a while and then bringing it back. There was a strong patent abolition movement, and Grove was very sympathetic to the arguments for the abolition of patents. He had seen firsthand the destructive side of the patent system, both in terms of inhibiting the manufacturers or sellers of wares from going about their business due to patents for quite simplistic things. He had seen the problems. He knew as a scientist how much he relied upon the work done by his colleagues, that he thought it would inhibit scientific development for for them to patent their developments. And there were some extremely there were some extreme challenges to the patent system at this time. So there had been, in one of the reasons why I'm interested in seeing if I can pinpoint the exact date of the Talbot letter, because Grove had many reasons, particularly before 1851, to object to the patent system. At this time, too, there was no there was very limited review of patent applications for the content. So there wasn't the examination process that we would have today. They could be rejected for lack of novelty, and it did happen sometimes, but no one was examining it carefully to see if the invention was new. It would be more if the officer looked at it and thought this is absolutely ridiculous and perhaps asked for an advisory opinion. So very, very limited review. If the establishment of the rights would be in the process of litigation usually, and that was thought to really be the only way to do it, much like with unregistered trademarks, that this would be a part of the litigation process. Also, they were very expensive. One of the things that the 1851 Act did was to reduce the cost, but even so, they were very expensive to obtain, and again, no review. The process was very unwieldy. And then right after 1851, because it becomes cheaper, there is this increase in the number of patents being filed. There were cases, talk of people filing a patent for a woman's hat style. So it was very much in development, and he was skeptical that all of the problems of the patent system could ever be solved in a way that would not have these disruptive effects. So Grove found himself, while on the side of patent abolition, being asked by Talbot to represent him in his patent infringement suits. They were not successful. So he did represent his friend Talbot, but they were not successful in demonstrating infringement. They did establish, or the judge found that there had been, that there were valid patents, the Cal-type patents were valid, but that they had not been infringed. There were slightly different chemicals used in the defendant's photographic process. So he used this to develop a patent practice. And so he was representing plaintiffs and defendants in patent cases. So it's clear from the subsequent decades that before his appointment to the bench, he had developed a patent practice. The other interesting contribution he made was, as I previously mentioned, he participated in the Royal Commission on the working of the law relating to letters patent for inventors. So this Royal Commission, it's fascinating to read the debates and the questions. They took very detailed minutes of the meetings, and the meetings they had over several years before producing a report on their recommendations for changing the patent system. Just as an example, we see here Grove using his experience in the patent system, noting that do they not occasionally meddle with you? Do not patentees of useless inventions frequently threaten litigation and cause litigation and expense? And the answer, this is an engineer, Richard Roberts, says, well, they may threaten. Do not you find that people actually embark in litigation upon patents which are frequently of small utility? Yes. Says Richard Roberts. Grove, of course, was a very active member of the Royal Commission in questioning the witnesses. which also included the very well-known patent agent Cartmail. Cartmail was probably the most well-known patent agent. So that profession of a patent agent, or what we might not call a patent attorney, who would handle the registration process for inventors, was already developing by the early to mid 19th century. And so Grove was particularly forceful in questioning Cartmail about the possibility of creating a more robust pre-grant review process. Grove was clearly trying to see if there would be a way to introduce some kind of patent prosecution system. So I think he would approve of that aspect of modern patent law. This is the example that I just gave of his this idea. He was pushing for there being some kind of pre-review. He was also pushing for there being some kind of specialized patent court. He saw the difficulty in litigation of explaining the technical issues to a judge or a jury who did not have the background to appreciate the nuances of what would be novel or what would potentially be infringing. So he was a proponent of there being some kind of specialist patent court. Ultimately, the Royal Commission concluded that it wasn't feasible at that time to have a specialized patent court that would only have specialist judges. But they agreed that the general proposal is that a judge on a trial of a patent case should either be aided by scientific assessors. So the idea was, well, maybe we could have the judges in patent cases have a team of assessors of experts to help them in their assessment, or that the case should be tried by a jury composed of from 5 to 7 scientific persons. The commissioners concluded that the latter plan does not appear to us to be wholly satisfactory, owing to the difficulty there would always be in getting a sufficient number of scientific men to compose a jury sufficiently competent and unbiased. So they went on and they decided that the best route to follow would be creating something modeled on the admiralty courts that would be a specialist court, but would involve the same judges from the courts of law and equity, so the judges of the Queen's Bench, but would have more support from scientific experts and would have a procedure that suited the idiosyncrasies of patent litigation. So Sir William Robert Grove, I've said he had this technical and scientific background. He developed a successful patent practice. He worked on other cases as well, but he certainly had a continuous practice in the area of patent law. He served on the Royal Commission on Patents, and as previously mentioned, he was then appointed as a judge, in fact, with the hope that he would bring his expertise in patent law to the bench, because they had seen from this Royal Commission, they had seen from experts in the area that there was a need for judges with an understanding of this specialized area of law and with the ability to understand the nuances and technical content that related to the inventions. So he became a judge. He was appointed to the Queen's Bench, and as is typical, he became Sir William Robert Grove. So he was knighted. On the bench, he considered a wide range of cases. It doesn't seem as though he really did sit on more patent cases than other judges, and there were criticisms of Grove for becoming too interested in the subject matter of the inventions, to the point of apparently giving inventors advice on how to improve them. So he may have been the first modern patent judge, but he was not necessarily a great success as the first patent judge. That said, perhaps receiving public criticism is also a characteristic of the modern patent judge, and so it fits right in with my thesis. So I want to come to one of the ways we see his this criticism is in his obituaries, which always seem to inevitably mention that he was appointed to be a patent judge and then was a little disappointing in that because he just got too interested in the material. And I wanted to read from one particular obituary from the Daily News on Tuesday, August 4th, 1896. The death of Sir William Grove, which occurred on Sunday, ought not to pass unnoticed. He was 85 years of age, and it is 9 years since he retired from the bench. But it is not as a judge that he will chiefly be remembered. He was one of the most distinguished men of science in a country and a time which produced Darwin and Faraday, Huxley and Tyndall, Sir John Herschel and Sir Charles Lyell. Half a century ago, Mr. Grove published his famous treatise on the conservation of forces. The central doctrine of the book is that the amount of natural force in the world cannot be diminished or increased and can only be redistributed. It goes on, I'm skipping a piece. Burton, in his Life of David Hume, describes professional eminence as an abyss in which some of the world's greatest geniuses lie buried. The metaphor is clumsy. The fact is interesting and remarkable. Mr. Justice Grove, trying a running down case or an action of slander, was perhaps as conspicuous an instance of misapplied talent and wasted energy as even the annals of law could furnish. When Lord Hatherley made him a judge, it was supposed that he would do good service in the administration of patent law. But he tried no more patent cases than other judges, and he did not always try them well. The proper place for a scientific expert is the witness box and not the bench. Mr. Justice Grove was a patient, courteous, laborious, and conscientious judge, but he could not develop his real powers in a court of law. He had to make a living for himself and his family, and he made it in that way. If he had inherited property like Darwin, he might have enriched English science with a series of splendid and fertile contributions. As it is, he has left a distinguished name and established a principle of the first magnitude in scientific philosophy. So was he the first modern patent judge? I think I have concluded that he satisfies my definition, but the more I read about him, the less I think he would want to be remembered as a patent judge. I think he would want to be remembered for his scientific contributions. And so I keep the question mark. And who knows, maybe as further developments on the fuel cell are made, maybe in the subsequent decades, he may be known more and further as a scientist rather than as the first modern patent judge. But that is the end, and I look forward to your thoughts and questions.
Hubert, you're muted.
Oh, sorry. Yeah, my fault. I should know better. Yeah, I've unmuted myself. I don't know if there are questions. Let me look in the chat box, but I do have a question for you. You used the word modern. What do you mean by modern? Like, why did you pick? It seems like you picked a time when patents went from privileges to an expectation. There was a time when, and it's interesting you mentioned the academies. If I remember correctly, patents were viewed very lowly. They were viewed almost as a vulgar way of protecting scientific discovery. Is that the reason? Is that transition from when it was a privilege and it became more commonplace to protect your discoveries? Is that the line you're making?
Well, it's partly that in the field of intellectual property historians, the middle of the 19th century has been sort of established as the point at which what we consider modern intellectual property law arose. So, for example, one of the sort of seminal works in this area is by Lionel Bentley and Brad Sherman. It's called The Making of Modern Intellectual Property Law, and it sets forth this argument and is sort of accepted as this. I mean, I am persuaded by their argument that yes, what we would consider to be modern intellectual property really emerges. There are lots of threads of this earlier on, as you say, privileges, but what we would consider modern intellectual property, actually even the term intellectual property really starts being used as an umbrella term during this period, sort of middle of the early to middle 19th century.
So you're saying around the 1850s, about that time?
Yeah, I mean, there are earlier examples, but yes, yeah, around the 1850s. I don't want to.
Yeah, no,
I don't
no.
want to paraphrase Bentley and Sherman's argument in a way that they would disagree with. Yeah, but I'd say around the 1850s.
Okay. So, and the other question I have is your term of judge. You mentioned patent judges. So you're speaking to a number of patent judges here on the Zoom call. And I think you're defining patent judge as a judge that's more in the judiciary, right? Someone who's trying cases or trying trial type cases.
Well, they didn't have administrative judges in Britain in the 19th century, so I'm saying I'm not sure I would define it that narrowly. I'm not sure I did define it that narrowly, but certainly in this case. Yes, I don't know. I mean, I don't think we have any other kind of judges to choose from in any of the jurisdictions I mentioned. So that's the only option we have, really.
Okay. All right. Thank you for that. Yeah, there is a question here. Do you know of any particular noteworthy cases or decisions by Grove?
There are some. Actually, the answer is not really, unfortunately, which is again why I would say the Talbot ones, as far in that was he was the barrister representing Talbot in those cases, but as a judge, not really. It said that he was meant to be the judge on Dudley and Stevens, but in fact they were a little worried about him, so he was supposed to sit on that, and they brought somebody else in that they thought would give a guilty verdict. So that would have been noteworthy, but they took him off it.
All right, very good. Anyone else online have any questions for the professor? Well, I thought your talk was absolutely fascinating. You're going to lead me to go do some more research here, just to try to see if it's true what you say. But I believe, I mean, I don't know if anyone with the kind of scientific background you discussed with Grove, I can't think of anyone like that.
Who's was like what, in the 1910s?
No, he was John Adams' nephew.
Was
I hear you, Jay.
Oh, sorry. we're debating whether or not there was
whether William Cranch could be be considered a patent
judge
back from 18. He's the nephew of John Adams. And
here's what I found.
Oops.
Yep. Siri's helping.
Yeah, we have a professor. We have a couple of judges.
Yeah. So William Cranch, is it?
William Cranch.
Yeah, William Cranch. Yeah.
I'll take a look.
Appeals from the patent office back in the 1800s. He was the Chief Justice of the DC Circuit Court back then, which is a court that doesn't exist anymore. And by statute, that position was the only judge that could hear patent appeals. And then he became sick and blind
and deaf.
And so the patent sat there for years because the statute wasn't changed to put anybody else to replace him.
And we're not sure about what his background was.
I don't know if what his technical background is, but I do know that he wrote several patent cases about patent law that made rules that still stick around today in the US.
Yes. Oh, so there are definitely, I mean, there were definitely judges who sat on patent cases. Of course, you know, it's just when I went through all the ones that we think of today, I couldn't find, you know, the sort of obvious people who wrote lots of judgments. I couldn't find anybody else who did, I couldn't find people who had some kind of, even if it was self-taught, some kind of claim to technical or scientific expertise and had a practice, you know, a patent practice. Which is, again, how I was defining it, which, again, you can always quibble with my definition.
Yeah, he was in that office from 1806 to 1855.
I will definitely take a look because I didn't look him up. So,
Did you look at us at all as far as the board goes? The board in the patent office, because we go back a ways, and then there are those like Judge Cranch who were even earlier than us, who have been dealing with patent cases. So we go back to 1861, and then we have Cranch, and then the Supreme Court. I don't know anybody in the Supreme Court. There may have been a justice who was a patent lawyer back in the 1850s, but forget his name. Maybe it was Custis or so.
Justice Curtis.
Was it Curtis?
Yeah.
Justice Curtis. I think he was a patent lawyer.
I looked him up, and I looked him up, and he didn't have scientific or technical background.
He didn't have no one. Yeah, I can't think of anyone like Grove with you know, with what kind of work he did scientifically. I mean, it's marvelous.
And again, I would even take self-taught, but Curtis didn't. Not that I could find. Like, he didn't have anything. I mean, he was interested in it, but.
Yeah, no, I believe you. I completely believe you. I never knew that.
But I don't claim that I've checked every possible person. So again,
no,
please,
I know you're
not.
not.
Anytime if you think of people that I can kind of test my theory on,
Yeah. Oh, we'll look after you go off. We'll look. We'll test you. But I can't think of. I can't think of it. I think you've done such a marvelous job, and you've really added to my thinking. I love that background, but what happened earlier before things started moving, especially, you know, everything started moving here in 1836, but there's a rich history in England that we obviously have inherited.
And I should have mentioned too that it's fascinating how quickly the U.S. system took off. It really did. So even though the U.S. system had been based on the British system, by the 1840s, the Brits are looking to the U.S. system for as a model. So that shift happens very early on, which is interesting to me.
Yeah. Oh, I love it. It must be fascinating what you're doing. The study, it's really rich. And what are you going to do with this? Are you thinking of publishing, or what do you have in mind for this? I think it's fascinating. I think a lot of people would be interested in this.
I'm not sure. I mean, this was kind of a side question. I mean, I really did work on this particular question for this audience when I was asked to give a talk. To me, it was sort of, it gave me this chance, as I said, to look into this question that I'd been thinking about for several years, related to my work on royal. I've done published quite a bit on 19th century royal commissions on patent and copyright, but maybe I don't know. I'm so fascinated by Grove now that I feel like I should do something more with it. So I'll have to think about it. But then I did come across this biography, which I did put in the chat, by the way. I'm not going to try to pronounce the author's name because it's
we see it. Thank you.
Welsh. But,
is this an answer?
It's cute.
Yeah, is that an answer to Judge Quinn's question about a biographical book on Grove?
Yes.
Is that,
Yes, that's
okay,
the one.
good. Yeah, fantastic.
Yeah, William
Okay.
Robert Grove, Victorian Gentleman of Science.
Yeah, I'm gonna get that book myself too. Thank you for that.
Yeah, it's in the Scientists of Wales series, which I did not know existed. And as I said, I feel bad now because I was probably a little snobbish when I picked this up. I thought, oh, there's a biography of Grove I haven't read in the Scientists of Wales series, and I was delighted by it, absolutely delighted. It was very well researched and well written. So,
Well, Professor,
I see another question. Is there a
no, I don't see one.
I see a
don't
hand up.
one. Oh, there is
Jason
a hand.
Morgan, or
Oh, yeah, Judge Morgan. Hey, Jason, did you have a question or so?
Yeah. No, I just wanted to know if you had any more insights on kind of what the role. I'm looking at that obituary that you read from, and I'm noticing that the writer was concerned that Sir William Robert Grove didn't confine himself to the legal question of infringement or non-infringement, and just thinking about a modern patent judge, at least here on the board, we don't deal with those. That's something that a district court, a generalist non-patent judge would do. We're focused almost entirely on whether a patent is even or patent claim is even valid. And I'm just wondering, was that an aspect of the of what a judge would do back then, or at least in the UK, or was it more, the patent had been issued and it just almost entirely came down to, was there infringement or non-infringement? It sounded like you mentioned something along those lines, but I'm just curious.
Oh no, they would consider validity. I mean, what is interesting, and this kind of comes back to this, the different roles of different kinds of patent judges. Like you could have the German system, you can have it bifurcated. There are lots of different ways to approach this, and so that was one of the discussions they were having, and one of the debates they were having before the commission, during the commission. And I think what I can tell from Grove's questions is that he tended to think that there should be some kind of, well, he thought there should definitely be more in the way of pre-grant review, which makes a lot of sense. And then I think he also showed some support of the idea of having courts that would just do validity after the fact, specialist courts that would just do validity after the fact, which is interesting. I mean, the next question I have in my mind, of course, is what would Grove think of the patent system today? Would he approve? Would he still be a patent abolitionist? Or would he say that actually many of the problems he identified have been solved?
Well, considering
that I can't say.
Considering we hear a lot of criticism of the same ilk today, it seems like it might not change.
No, exactly. It might not change.
As time goes on.
Yeah, the problem, many of the problems that he identified have been addressed, but they haven't solved the ultimate issues that he was troubled by.
Yeah, he's still relevant. Yep. Well, do you have would you mind if we test your theory and contact you if we find find a weakness in it? Well, I'm sure we won't find anything.
Please do. No, I get it, and I'm not sure. I'm not planning to publish anything on this point anytime soon. I might give it as a talk elsewhere and see if I can just kind of gather information on the subject. But yeah, so no hurry, and I would be delighted to hear any other names or ideas, or if you have any suggestions. I mean, maybe I need to work with my definition as far as making it clear that this would encompass anyone deciding patent cases with this background, regardless of the kind of stage of proceedings. So
yeah. The term judge has grown to cover a lot more areas, and definitions are important. You said you covered England, Holland, Spain, Germany, and America.
Well, I focused in kind of looking for possible judges. I looked at US, UK, Spain and France.
Oh, and
just
France. Okay,
because
very
they
good.
had the early, they all had patent systems set
Yeah.
up in the early 19th century.
Yeah, they did. They did. Yeah. Yeah. Very good. Oh, excellent, Professor. Excellent. Well, I think it's about time to go. I don't see any more questions. I will give everyone a few more seconds. Raise your hand if you'd like to make a comment. No, I don't see anything. Okay.
Well, thank you so much. It was a lot
Yes.
of fun for me, and I really
Thank you so
appreciate,
much.
the opportunity.
Thank you so much. Take good care. Thanks.
Bye.
Bye.
Turn off the recording.